Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Academy program and our first webinar in the 2025 series. My name is Nidhi Kilawala and I am an M&A partner in Khaitan's corporate M&A group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. The M&A Academy program is designed to provide foundational legal knowledge and understanding on M&A transactions and processes to corporate executives, in-house legal teams, and others participating or interested in M&A in India today. Our subject today is what's market in Indian M&A private share purchases. On this slide is the agenda for today's webinar. We have already received several audience questions. And if you do have questions, please feel free to submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes of the discussion, and a recording of this webinar will be sent to you after the webinar as a matter of course. M&A is an important part of our firm's practice with more than 50 partners dedicated to this area because India is experiencing massive growth in M&A transactions. Today's topic is particularly important given that India has become one of the most followed and active equity capital markets globally in the last year with record levels of issuances. The country is benefiting from a thriving economy and a booming startup sector. There's a high level of conviction among global investors, both institutional as well as private equity investors, on the opportunity that India represents. Understanding trends in India's M&A landscape is therefore crucial for businesses, investors, and policymakers alike for several reasons. It can help businesses stay ahead of competitors by capitalizing on industry shifts. Two, it can help in assessing valuation trends, deal multiples, financing structures, and so on. It is also particularly helpful in competitive processes to ensure that the buyer is not left out of the race due to demands or expectations that buyer may make that are perceived as off market or unusual. And lastly, I think it is particularly helpful in understanding a landscape which then helps ensure that buyers leverage opportunities and mitigate risks in India's rapidly evolving business and regulatory environment. Everyone who has signed up for the webinar today would have already received by email a summary of the speakers and their credentials to talk today. So I will not spend much time on introducing them. Suffice to say that they are experts in the field of M&A and are the right folks to talk us today through the topic that we will be discussing. Our presenters today are Aishwarya Nagpal, Nayantara Kutty, Pashupati Nath, and Rahul Jain. It is with immense pleasure that I introduce them to the audience here. And I'd now like to kickstart the webinar with some of the questions that we'd like to discuss today. And with that, my first question is to you, Aishwarya. Thank you for being with us here today. So, Aishwarya, I'll go right into it because one of the most talked about discussions in an Indian M&A context is indemnity. And indemnity is truly one of those hotly debated clauses in an M&A deal in India. In your experience, why are indemnity provisions crucial in such deals? And linked to this, who, in your opinion, is typically the indemnifying party, and how is that clause typically negotiated in India?
Hi Nidhi, thank you so much for this. And this promises to be an interesting one. To just answer your first question, I would say that negotiations around indemnity are always, it's that one topic that we start discussing at the start of the transaction. And it's belabored right till the very end. And it's those last points that the parties eventually agree on. And this is obviously because indemnity as a construct is extremely important for both sides. This is because it results in tail liability for the exiting shareholders. And obviously, this is after they have sold their stake. And on the other hand, for the purchaser, it continues to be the primary recourse in the event things go south. So obviously, both from both perspectives, indemnity becomes extremely important. To answer your question on who are typically indemnifying parties, I would say that for minority or non-control transactions, you typically see the sellers and the company as the indemnifying party. And in the case of multiple sellers, there'll always also be discussions around whether their liability will be joint and several or only several. Now, where the company is an indemnifying party, it's common to also provide for a shareholder gross up to effectively make good the purchaser for its shareholding in the target. Now, this is slightly different in a buyout transaction because here you will not see the company as the indemnifying party, but instead as the indemnified party. And this is obviously because here the company becomes the purchaser's asset or vehicle. Now, just one more nuance here, which is in the case of fund sellers. Now, here the conversation becomes slightly more tricky because of issues around fund life and whether the fund will have the ability to honor indemnity claims should they arise. So, what we commonly see where the seller is a financial sponsor, you'll see that the purchaser will require a LP or GP backed equity commitment letter or a comfort where effectively the limited partner or the general partner undertakes to be liable for obligations of the fund seller in the event the fund is wound up before the expiry of the indemnity obligations, or the LP or GP will commit to ensure that the fund will at all points have access to monies to honor its indemnity obligations. Now, the other alternate construct where there are no ECLs, etc., is basically the construct of W&I insurance. But I won't spend time on this now because I'm sure we'll sort of deal with this as we go along. With this, I'll hand it over to you, Nidhi.
Thanks, Aishwarya. That was very, very helpful. So, related to that, then I think the natural next question that we go into after understanding, the four corners within which the indemnity is to be provided, is what are the typical survival periods, in your experience, for non-tax related indemnity claims?
Yeah, I think this is extremely interesting, and in almost all M&A transactions, we're asked by our clients on what our take on this is. So I'll just share my experience here. So I would say that for non-tax matters, the market practice and indemnity coverage is a bit varied, and to some extent, it depends on the kind of M&A process at hand. So, in the case of highly competitive auction processes that we are seeing more of these days, sellers are taking quite aggressive positions, while in bilateral transactions, the indemnity coverage, I would say, still continues to be more buyer friendly. I'll just break down the various indemnity events and offer some standards here. So for breach of fundamental warranties, which is basically warranties relating to title, capacity, and authority, in most transactions, I would say we're still seeing buyers pushing for, and in fact even succeeding in negotiating a perpetual right to claim indemnity. As I said, in more competitive transactions, we're seeing this shortened to about 7 to 10 years. In terms of monetary caps, I would say, irrespective of the kind of process, this is fairly market at 100% of the purchase consideration. The next would be business warranties. And I would say that the market on this has really shifted in the last 3 to 4 years. And in terms of time caps, the survival period for business warranties has come down to 2 to 4 years, and I would say this is because buyers are now sort of confident that 2 to 4 audit cycles are sufficient to expose any claims relating to the operations of the target. In terms of monetary caps as well, I think it's quite tough now to land with 100% cap on these matters, and the market is moving to about 50% of the purchase consideration. The other bucket here is breach of covenants. And I would say that in about 50% of our transactions, indemnity for breach of covenants is uncapped in terms of time, with the monetary cap being about 100%. While in the other half, we're seeing time caps of, I would say, 2 to 4 years. The important thing to mention here, though, also is that indemnity for covenants is now typically limited to an identified set of provisions. So it's not just a general indemnity for all breaches. The parties would now sort of identify a much shorter list, and this would typically include provisions like exclusivity, non-solicit, non-compete, etc. The last bucket is obviously fraud. And on this, the market hasn't moved at all. And I would say that fraud still continues to be excluded from all limits and liability. Just to conclude, I would say that on indemnities, there really isn't a one size fits all approach. And obviously, several aspects like comfort between the parties, risk appetite, nature of transaction, DD findings, etc., all of these sort of play a role in how the indemnity is finally agreed. I hope this offers some perspective, Nidhi.
It does. Thank you for that, Aishwarya. Extremely helpful, and I think in many ways gives us a good glimpse into the different categories of indemnity triggers and the manner in which both sellers and purchasers are now trying to move towards a more reasonable outcome. I think not so long ago there was a scenario where in most deals you would see buyers insisting on 100% caps on items like business warranties coverage as well. So good to see your perspective on how market is probably moving towards a more reasonable outcome. Thank you for offering that perspective. I think moving on, then it might make sense to get Rahul in on this discussion with his experience on dealing with tax matters in India. Rahul, how would you say everything we just heard from Aishwarya on indemnification triggers and limits for non-tax claims? How do you think that plays out in the context of a tax-related indemnity claim?
Sure, thank you for that, Nidhi. And I think that's a very pertinent question that you raised. You'll often see advisors and the councils negotiating the tax indemnities, and it gets negotiated at the last minute until you're signing the agreement. And therefore, it becomes imperative to understand in what context are you looking these indemnities and what are the risks that you are trying to cover when it comes to a tax indemnity. For example, you could be doing a share purchase agreement where the seller would be a non-resident. Now, under the law, as a buyer, I'm required to withhold the taxes, and any non-compliance to those has a repercussions on the buyer. And if I were to put it in clear words, it could result into the taxes of sellers being levied on the buyer or recovered from the buyer. Now, therefore, that's a clear allocation of risk that needs to be undertaken by the parties. That because those are the taxes of the seller, the general principle is, of course, that the seller should bear it, and in case the tax authorities comes after the buyer, there needs to be, and therefore the question of indemnity. Now, and hence the moot question is: are you withholding the taxes or are you not? It's more relevant when you're not withholding the taxes, and that could be various reasons. For example, the seller is a Mauritius tax resident, they acquired the shares prior to 1st April 2017, and therefore they're claiming an exemption from taxes in India under the India Mauritius Tax Treaty, like how you would have seen for Tiger Global and Blackstone related cases which are there in the market. And hence, if you're not withholding the taxes, the seller prefers you to rely on their position. If at all there was a dispute to arise and there is a consequential risk for the buyer does need an indemnity or a protection to that extent when it comes to a transaction. And in that sense, what we have generally seen, Nidhi, is while the markets have been fluid previously, in terms of what the survival period should be, whether it should be 5 years, 7 years, or 10 years, because the statutory period was very flexible in terms of the maximum period it could go is up to some time back up to 10 years also. But now the statutory period have come down to a 6 year period, and therefore what we are now witnessing in the market is, at least in those type of cases where you are not withholding the taxes, the survival period is back to the statutory period or a definite number of 6 years. Coming to a case where you're withholding the taxes, now the natural question there is, therefore, do you really need an indemnity? And of course, that depends on the facts and circumstances of each case. But as a principle, if you're relying on the information being supplied by the seller, and there are certain technical positions being undertaken when you're determining the withholding taxes, it's for the buyer to decide whether they are comfortable with that position or whether they need an indemnity. Often we see buyer and seller agreeing to an indemnity there as well, but the survival periods are often reduced because the risk that extent parties believe is lower as compared to a situation when you're not withholding the taxes. And hence the survival period that there ranges generally from 3 to 5 years. Now, the third bucket, which I would like to talk about in this section, is company level taxes. And this is more relevant when you're looking at a transaction where this buyer is acquiring a majority stake or it's a strategic buyout. And they, of course, need a protection in the sense of, any liability pertaining to the company which pertains to the period prior to the closing. There is a ask that the promoters or the existing shareholders should indemnify the investor, naturally, because those are the past related issues, and of course, investor would not be able to be, bear a loss to that effect. There, Nidhi, what we are seeing is the market, because the statutory period have now come down to a 6 year period, and even previously this was more or less linked to a statutory period. A 6 year period is what we are generally seeing in the market. In terms of caps, when it comes to company level taxes, like Aishwarya explained, it's treated akin to business warranties, and therefore, while having 100% cap of the purchase consideration is the best position for the buyer, again, a standard practice or the market practice is now somewhere ranging between 30, 40, 50% depending on each case. For the seller related taxes, I would say depends on the seller related factual position, but the principle again is you cover the taxes, you cover the interest, and you cover the potential penalties of it. Right? So I think Nidhi, that is how I would look at in terms of the overall tax indemnity package when it comes to seller as well as company related taxes.
Oh, very, very interesting. Thanks for that, Rahul. Maybe just a related question to that, then, and we'd love to hear your thoughts on this is how would this answer change when you think about payments that a purchaser needs to make, right? So I think we've sort of understood how or what is market rather in the context of claims that a purchaser may make against the seller with respect to tax related warranties. But once that indemnity comes to pass and say the payment has been made by the seller, does a receipt of that indemnification amount result in discharge of taxes by the purchaser? And if it does, like what, in your experience, is the typical standard in case of gross up in such cases?
Sure, Nidhi. And that's a very valid question in the sense that it forms part of your overall indemnity package and the negotiations that the parties undertake. Now, I'll just give a brief background on why the tax cross up or what is this tax cross up for a larger audience. Let's say the parties have agreed to an indemnity and there is a loss situation which has actually occurred. In that sense, the buyer is required to, let's say, make a tax payment of $100 or 100 INR. Now, when the seller makes that indemnity payment to the buyer, if there are any taxes to be withheld or if the taxes are to be paid by the buyer, it will naturally reduce your indemnity payment and therefore reduce the ability of the buyer to, pay the entire loss amount out of the indemnity payments. For example, let's say the loss is 100 and the buyer is liable to pay tax of 30, the net amount it holds is 70. But and therefore to that extent the buyer goes out of pocket. If you were to look at it very logically, the indemnity trigger or the loss has arisen because of the a breach of a warranty or certain indemnity events that were agreed to between the parties under the SPA, and hence it is very rational for the buyer to expect that those taxes should also be borne by the seller. Now, therefore, the question comes is how do you determine whether there is a tax payable or not? And that could be various technical arguments to that effect as well. But as a principle, if let's say there were taxes to be paid, the parties generally prefer, the buyer would of course prefer that seller pays it. What we've seen in most of the deals is the parties do agree to a tax gross up. Now, but it's also of course balanced in the sense that you don't, as a seller, I need some visibility on my potential outgo, and therefore the question is, does it tax gross or falls outside the scope of my overall indemnity limitation, the cap, or should it be within the cap? This becomes often a point of commercial negotiations. If you ask me, there are the cases where it has been outside the scope or within the scope. there are cases on both the ends. Majority of the times, depending on the deal, again, it could form part of the overall indemnity cap. But then the seller also says that, okay, while I'm agreeing to the gross up, if let's say as a buyer, you tomorrow get a credit of this taxes or you benefit out of it by claiming a refund of it, please pass it on to the seller. And that is, of course, a very consequential event, I would say. And hence, in terms of the overall negotiation, this is how it would fall in place, Niti, when it comes to tax cross up.
Thank you for that super detailed and helpful response, Rahul. Maybe just taking a cue from that, I think both you and Aishwarya mentioned in common that eventually how your indemnity package looks is a function of the facts in question, and whether whether there are certain specific DD findings, or there are certain items in the particular transaction that have resulted in risk allocation being done through the indemnity process. So just related to that, and maybe I can bring Pashupati into the conversation with this question. Pashupati, what has been your experience with specific due diligence findings, if any, that a buyer may have discovered as part of its due diligence process? Do you see those typically sort of being included as specific indemnities in M&A deals in India?
Thank you, Nidhi. In short, the answer is yes. It's quite common for specific indemnities to be negotiated as part of Indian M&A deals. The underlying rationale stems from the fact that businesses in India continue to be regulated, be it in terms of taxes, payment of statutory benefits to employees, or obtaining various consents from regulatory authorities to run their operations. Accordingly, it is not uncommon for issues to be identified pursuant to due diligence exercise undertaken in relation to a target by an acquirer. And if there are issues identified, then parties tend to negotiate specific indemnity in relation to the same. In our experience, I think the parties should consider three key principles while negotiating specific indemnity matters. First one is what should be included as a specific indemnity matter. Now, to the extent any issue identified during diligence is likely to have a significant impact on the assumptions made by the acquirer, either in terms of future operations or in terms of financial assumptions which the acquirer has made to arrive at an equity value, then it is reasonable for the acquirer to protect itself by seeking specific indemnity. For instance, say for example, if the acquirer is acquiring a manufacturing entity or a hotel, and if the title to the land itself on which the hotel or the manufacturing facility is constructed is not verifiable, then it is reasonable for the acquirer to protect itself and seek a specific indemnity in relation to the same. The second one being is what matters should not be included as part of specific indemnity matters. See, in this regard, it is important to understand specific indemnity is not intended to grant protection to the acquirer against seller's right to disclose. Accordingly, issues identified during diligence which are not likely to have a material impact on valuation or operations should not be included as part of specific indemnity matters. In addition to this, in fact, issues identified during diligence which have already been considered or adjusted while determining the equity value should also not be included as part of specific indemnity matters. For instance, in various cases, we have seen that the target have not made appropriate provisions towards gratuity liability. Now, the one way to approach this issue is seek a specific indemnity, but may not be the correct approach from acquirer's perspective. So what acquirer typically do on the basis of actuarial valuation, they will do an upfront adjustment to the equity value. If an upfront adjustment has already been done in relation to this issue, which has been identified, then it is not fair that the same is included as a specific indemnity matter as well, because it will result in a double dip for the seller. The last principle that parties should consider is whether the specific indemnity matter should be subject to any form of limitations that Aishwarya and Rahul have discussed. Generally, specific indemnities are devoid of any time limitation or indemnity cap. However, based on our experience during last couple of years, we note that the sellers nowadays tend to negotiate caps and time limits in relation to specific indemnity matters as well, especially where the specific indemnity matter and the liability in relation thereto can be quantified. In terms of time limit for making a claim, we see that the sellers are looking at the same time limit as for breach of tax warranties, whereas specific indemnity matter relates to a tax issue. And for non-tax related specific indemnity matters, the time limits proposed are the same as for making claims for breach of business warranty, which Aishwarya has touched upon. I hope, Nidhi, this gives a flavor of how specific indemnity matters are being dealt with in the current M&A scenario.
It does. It does. Thank you so much for that, Pashupati. I think after all of that conversation about indemnity, I think what's becoming amply clear is the seller may not get a clean chit post closing, and there will always be some kind of obligations that may continue post closing that could result in indemnification payouts depending on how that package is negotiated. So maybe turning to you, Nayantara, just taking that principle forward, are there alternates that you're seeing in the Indian M&A deal making space where a seller is insistent on wanting to get a clean chit? And saying, you know what, the closing has happened, I've sold my shares, I've got my purchase consideration, and now any liability that flows through should ideally not flow to the seller in question. So, are you seeing nil recourse type arguments, A, being made by sellers, and B, if they are being made, how are buyers sort of managing that going forward?
Thank you, Nidhi. And I think that is a very important discussion while you're discussing indemnities. Now, Nidhi, in a nil recourse deal where the seller doesn't want to provide indemnities, again, for the deal to actually go ahead, the parties then rely on a rep and warranty insurance, which then becomes a very important tool and in most cases ends up being the main reason why the deal has gone ahead, because it bridges the gap between what the seller offers versus what the buyer needs to be comfortable to go ahead with the deal. Now, it's not just in nil recourse deals. It's also in other situations where the buyer is simply not comfortable with either the quantum of the indemnity offered. This can be because the caps that have been negotiated are extremely low, and therefore the insurance policy provides the additional coverage. Or if there is a concern about the seller's ability to actually make good an indemnity claim. Now, this can arise where there is a PE fund and the fund life is coming to an end, or there is no backstop of the indemnity by the LPGP, or there is no equity commitment letter provided in relation to an indemnity provided by an SPV, or there are concerns about a seller's solvency. So in all of these situations, the rep and warranty insurance comes to the rescue. And let me spend a minute on how this plays out. Effectively, instead of a indemnity claim being made against the seller, the buyer, assuming it's a buy-side policy, will make the claim against the insurer, and the policy then pays out the amount of loss suffered by the buyer. So effectively, instead of the seller, the insurance policy is paid out. Now, this significantly reduces the financial burden of the seller, and therefore we've also seen this in auction processes where, in order to make the bid more competitive and to sweeten the deal, the buyer agrees to procure a insurance policy, and it also reduces the time spent on negotiations. Now, a softer aspect of using a rep and warranty insurance is that it also reduces the likelihood of a dispute between the parties, because you no longer, in case there is a dispute regarding an indemnity claim, it will be with the insurer instead of the seller. So it also helps preserve relationships in the M&A market. In terms of trend, it's always, in most cases that we've seen, is a buy-side policy, and that usually covers fundamental tax and business warranties. And in most cases, you will be able to get it across sectors, except where there is certain legal uncertainty. However, now the rep and warranty insurance, what we've seen, does not necessarily mean that the indemnity package is gone away. Like I said, there are situations other than nil recourse. So typically the rep and warranty insurance is negotiated in tandem with the indemnity package, because there are certain exclusions such as anything that is disclosed. There may be a de minimis amount. So the buyer would typically seek to get recourse from the seller for these exclusions. And therefore, what we've seen is that the broad terms of the insurance policy is agreed at the time of execution, while the policy may be procured as a pre-closing condition rather than a post-close. And in terms of And again, in terms of usage, what we've typically seen is while large private equity funds are using this often, but the strategics are also picking this up for their big ticket deals. So, Nidhi, to conclude, rep and warranty insurance is here to stay. It is an important product, and we will see a lot more usage of the rep and warranty insurance. It's also a function of the fact that today insurance premiums are falling and more insurers are offering this product, and with more awareness and the parties seeing how useful this is in situations where it may have the deal may not have even consummated, rep and warranty insurance is really the reason why the deal went ahead. So over to you, Nidhi, in case you have any follow-on questions.
Absolutely. No, thank you for that, Neta. I think all this conversation around the rep and warranty insurance and what it really seeks to provide both to the sellers and the buyers, that makes me wonder, what are buyers expecting in the context of coverage as far as representations and warranties are concerned. So maybe we can bring Aishwarya in on this to shed some light based on her experience on, Aishwarya, what have you typically seen buyers ask a seller to provide as part of the representations and warranties in a sale transaction?
Yes, I think we spent like the last 30 minutes on indemnities. So I think from that, it's evident that really indemnities are the cornerstone of most transactions. And therefore, what purchasers seek in terms of reps and warranties becomes extremely important. Most of us have been in situations where we've either received a 25-page rep package as part of an SPA from the other side, or have sort of been guilty of doing this ourselves. So you can understand that as the purchaser, you'll always try to cover as much as you can. So with this, I'll just go into the kinds of reps that you will see in an SPA. The first category is that of fundamental warranties. These typically include matters like title, capacity, and authority. So it's basically comfort around validity and ownership of shares and the shareholder's ability to transact. Now, sometimes the scope of fundamental warranties will extend beyond this. So, for instance, in a real estate transaction, you will see that fundamental warranties would also cover aspects relating to title of property and land, and this is, for obvious reasons. And in transactions involving financial sponsors, you may also find ABAC or AML reps to be covered as fundamental warranties, right? So the scope of fundamental warranties would slightly vary depending on the context of the transaction. The next bucket here is business and operational warranties. Now, this, as you can imagine, is the most sort of comprehensive section of the reps, and this is because it covers all operational aspects of the business. So to give you examples, this would include matters like corporate structure, ownership and right to use intellectual property, regulatory compliance, environmental compliance, foreign exchange law compliance, matters in relation to ownership and leasehold rights on properties, employment and labor aspects. Now, obviously, the focus of business warranties varies depending on the sector in which the target operates. So for IT companies, you will see that a large portion of the business warranties will be around aspects like software and source code. And on the other hand, for instance, for a pharma manufacturing target, you'll obviously see more focus on aspects like compliance in terms of pricing norms, marketing practices, regulatory approvals. Right, so obviously some part of this depends on the target that you're looking at. The next bucket that you'll typically see in an SPA is tax reps, but I'll hand it over to Rahul to discuss those with you.
Sure. Thank you, Aishwarya. And I think you very well summarized in terms of what the business warranties entail and why it has to be so comprehensive. And just picking up from there, the same principle applies to when it comes to tax warranties. And you could again be discussing those in terms of seller tax warranties or company tax warranties. When it comes to seller tax warranties, the key warranties that you would generally look out for is on the residential status of the seller, because that is what will determine your withholding tax obligation. And then everything else is consequential in terms of whether the seller is holding the shares on as an investment or as a stock in trade, whether the seller is if the seller is a non-resident, do they have a taxable presence in India or a permanent establishment in India, and so on and so forth. Right? So I think when it comes to seller tax warranties, the market is well settled in terms of what is expected in terms of warranties. Um, and at times it does get overboard where the and it does get negotiated as a part of your overall rep and warranty and indemnity package. So it's something to deal with the withholding tax position of the buyer. Now, coming to the company taxes, that is where the a bouquet of warranties is what you would see. What you plan to cover is essentially, has the company been compliant with the tax law? Have they paid applicable taxes? Have they made applicable provisions in the books for the potential taxes that may arise? Have they recorded all the receivables correctly? Right? And do they have any outstanding tax proceedings? So those are typical warranties that you would see now. When it comes to the taxes of the company. Key other warranties when it comes to company is, if let's say there's an Indian company which has overseas affiliate and there are transactions between the Indian company and the affiliate, have those transactions been undertaken at arm's length from a transfer pricing standpoint? And these are also relevant because, like Nanta was explaining, if you're looking for a dub or rep and warranty policy, it does have certain exclusions. Some of them are standard, and transfer pricing being one of them. And certain other key warranties as the law keeps evolving. For example, you have general anti-avoidance rules in place. You may want to have we've often seen the SPAs providing for a warranty to that effect. Right? And I think additional warranties kicks in if you're looking at a transaction which is an indirect transfer. That is, let's say you're a buyer, you're buying shares of a US company which holds shares in an Indian entity. Now, therefore, whether US entity derives substantial value from India or not, because that is again what will determine your tax implications. So I think with that, maybe we'll hand it over to you in terms, and we hope that gives an overall perspective on how the reps and warranties plays out in terms of tax and non-tax.
Thanks for that, both Rahul and Aishwarya. I think very, very helpful to understand what is the gamut of warranties and coverage that a buyer is sort of expecting in Indian transactions of late. But I'm just going back to first principles, right? I mean, you hear so much about due diligence processes and buyers spending a plethora of time, effort, and money on naturally diligencing the asset that they're going to buy. And so, why should a seller have to indemnify for known items that sort of purchaser was aware of, either through its due diligence process or because, say, seller has made the buyer specifically aware of those, say, non-compliance or certain ongoing sort of measures that they may be taking with respect to items that need to be fulfilled. So, just in that light, Nayantara, like, why do a see buyers insist on the fact that they still need coverage despite knowledge of items, and b what are you seeing sellers push for from a disclosure standpoint, because buyer is beware once they've been told about some of the outstanding issues.
Thanks, Nidhi, for that. And that's a very common debate that we have when we're discussing indemnity and disclosures. Now, what you describe, where the seller's, the buyer's knowledge precluding him from making a claim, is an anti-sandbagging clause. Now, basically, what an anti-sandbagging clause does is that it prevents the buyer from making an indemnity claim against the seller if there is a breach that the buyer was aware of pre-closing. So effectively, the buyer's knowledge, whether it's gathered through a diligence or through discussions or any source, acts as a shield for the seller against an indemnity claim. However, what's actually market is a pro-sandbagging clause, which is basically the buyer's pre-closing knowledge does not in any way impact the ability of the buyer to claim for breach post-closing. Again, the rationale for this is that the diligence that the buyer does is for his benefit and not to dilute the ability of the buyer to claim indemnity or rely on the reps and warranties provided by the seller. So now again, like you mentioned, that this always is a tussle. So how would you balance this? Now, what the parties have agreed, and typically is the standard, is that you'd have a disclosure, which is an exception to the pro sandbagging clause. Now, in terms of what's market for disclosures, in the Indian market, in bilateral transactions, buyers are not comfortable with broad disclosures like data room disclosures. So the trend continues to be specific disclosures against identified warranties. And this is crystallized in a disclosure letter. In auction processes, of course, what we've seen is, again, to sweeten the deal and make the bid more attractive, the purchaser may accept a higher standard and may in certain cases accept vendor due diligence reports filings made with the registrar of companies and accounts. In a very small percentage of deals, we've seen that data room disclosures are accepted, and on examination, we've noticed that this is where the buyers come from jurisdictions where it's market to accept data room disclosures. Now, in terms of what is the standard of disclosure, you would typically agree that it should be fair, complete, and in the Indian context, specific. And in terms of what constitutes a fair disclosure, it should be that the disclosure gives the buyer sufficient information so that he is able to determine or ascertain the implications of the disclosure and make an informed choice. Now, while we've typically seen that the disclosure letter is provided at execution, if there's a significant time gap between signing and closing, the seller will want the ability to provide an updated disclosure letter. What's market is that the seller should only update for matters that occur between execution and closing and not events that have occurred prior to execution. The rationale for this is that the buyer would have factored in the implications of the disclosures made in the execution date disclosures, may have done a purchase price adjustment, may have put in a CP or a CS or even a specific indemnity. However, Nidhi, what's very important is that the parties negotiate or discuss how disclosures treated in the updated disclosure letter. And Nidhi, back to you to pick up what are the implications of new disclosures you would see in an updated disclosure letter.
Absolutely. No, thanks for that. And I think that's a great segue to, the next question that I had, and that will unfortunately be our last question for the panel today. Our chat box has been buzzing. So I think I'd like to get to our audience questions as well. But before I do that, Pashupati, I think the question that are left with the group, right? Like, if there is an updated disclosure that has been made by a seller between the sign and close of a transaction, and say it's too lethal or toxic as far as purchasers' risk appetite is concerned, how are you seeing parties agree on the disagreement of the addition of that disclosure?
Thanks, Nidhi. This is an important question because the acceptance of matters disclosed in an updated disclosure letter goes to a deal certainty issue, which is equally important for both the seller or the target and the acquirer. Now, typically preference of a seller or a target is to have unfettered right to disclose matters which have occurred between signing and closing. However, from an acquirer's standpoint, they will prefer that the updated disclosure letters are either in agreed form or it has a right to walk away from the deal if the disclosures are not acceptable. Acquirer's position will not be acceptable to a seller because an agreed form document means if the parties can't agree, then there is no obligation to proceed to closing. Similarly, the seller's position that they want an unfettered right to disclose is not acceptable to the buyer because if something very material happens, then why should the buyer proceed to close? To bridge this gap, we have seen parties considering and agreeing to proposals which addresses concern from both parties. And in our experience, the approach which we see is amenable to both the parties is as follows. If an updated disclosure rises to the level of a material adverse effect or a material adverse change vis-a-vis the company, business, or its operations, it is fair for the acquirer to have a walkaway right. In relation to updated disclosures, which do not rise to the level of material adverse change, but are still likely to have a significant adverse financial impact, then parties consider that such disclosures may automatically form part of specific indemnity matters, unless it is otherwise agreed between the parties. Now, in this situation, it is important to negotiate a financial threshold as well. So, what matter should form, if contained in updated disclosure letter, part of specific indemnity? In our experience, both the buyer and the seller try and link this financial threshold to the de minimis or the basket, which is agreed as part of the limitations of liability. The last one being, if updated disclosures do not rise to the level of material adverse change or even does not have a significant financial impact, then they are deemed to be accepted without any adverse consequence for the seller or the target. Hopefully, Nidhi, this provides guidance in terms of how do we deal with updated disclosures in Indian M&A scenario.
It does. Thanks very much for that, Pashupati. Like I mentioned, we'll now move to some of the questions we've been receiving in our chat box, and I'd request all the panelists to kindly turn on their videos so we can discuss these questions now. I think our first question, maybe I'll put that to you, Rahul, since it relates to a tax point. A question we have from our audience is, are caps applicable in terms of limitation of liability? And are they subsumed within the tax gross up, or are they in addition? Is the tax gross up over and above the aggregate cap that gets negotiated, which Aishwarya helpfully spoke about?
Sure, sure. Thank you, Nidhi. And we did touch upon this in our discussions, where we are saying that when you're looking at tax indemnities, there are caps which do get negotiated, and it depends on the risk that you are trying to cover. For instance, if you're looking at a seller-related tax indemnity, your caps are uh, that you want to cover as tax, interest, and penalty, and therefore that's a one would need to do that computation and see what percentage of the consideration that comes to. For example, if you ask me, when you're looking at a seller who's claiming an exemption, what we typically see is tax is 1x, penalty is 1x, and the interest for the period of indemnity. So let's say if you're agreeing to a period of 6 years, 2.72x of the tax amount is what you're looking at an indemnity cap. And I'm not saying that's the cap people always agree to. That's a general remark that we've generally seen in deals. And similarly, when you're looking at a case where there has been withholding happening, the caps are of course on the lower side because you've actually done the withholding on some part of it. When it comes to company level taxes, like we discussed, treated a key to business warranties to 30 to 50% of the purchase consideration, and the tax gross up over all of this. Um, if you ask me, a best deal would be, or a more balanced deal is what we've seen is all the caps being subsumed, including the gross up within the purchase consideration. I hope that addresses the question.
Yes, thank you for that, Rahul. Maybe I'll put the next question to Aishwarya, given the helpful inputs, Aishwarya, you left with us on limitations of liability for non-tax related matters. One of our audience members has a question on, is there a limitation period for fraud related claims?
So to answer that, Nidhi, I would say that for fraud, it's perpetual. So as I said, it's excluded from all indemnity caps. I haven't come across instances where sellers have also pushed for liability in relation to fraud to be capped. So in general, I would say that the principle on fraud is that no sort of contractual limits apply to it. So no de minimis, no basket, no monetary caps, none of that. So really a fraud claim survives all of that.
Very helpful. Thanks for that, Aishwarya. Our next question, maybe if I could request Nayantara to throw some light on this, is Nayantara, what has been your experience on the standard that's being agreed between parties to seek consent by the seller from the buyer during the interim period of signing and closing?
Thank you for the audience for the question. Now, generally, you do like to strike a balance between, what the seller wants in terms of flexibility to do business versus what the buyer would want some control from a value perspective. So what we've typically seen is that there are some bells and whistles put in place. You would have a short list of what we would typically call standstill obligations. It's really generally not linked to what you would have as reserve matters in the shareholders agreement, but really value protection matters such as starting of new businesses or hiring of material assets, really to protect the investment that the buyer has done diligence of. And really extraordinary items such as bringing in new borrowings above a particular threshold. In such situations, we would see that the parties agree. But the most common standard that you would see today in all transactions is the seller's obligation to carry on business in the ordinary course of business and consistent with past practices, because the logic there is that the buyer would have analyzed what's been done so far as part of the diligence. The seller is also comfortable that he can carry on the business. So, Nidhi, I hope that answers the question.
Yeah, no, that's very helpful. I think the one thing that I will add to that is, this becomes particularly interesting to consider, especially in a deal where, say, prior regulatory approval of the Competition Commission is required, right? And then you go into aspects like, would seeking this consent prior to receipt of that approval result in any gun jumping risk for the transaction, for example? So everything that Nayantara said, I think, is super helpful in the context of what we're typically seeing, but this will need to be balanced in the context of that particular transaction, if at all any prior approvals are required. So thanks for that. I think the next question, maybe I can bring Pashupati's thoughts on this. Pashu, if you could help us answer, what are you typically seeing? I mean, everyone's clearly spending a lot of time negotiating all these deals. If the deal were to sort of not be closed for any reasons, whether it is, a non-fulfillment of conditions precedent, or well, there is some kind of macro factor that has had a knock-on impact on the viability of the transaction. What are you seeing? How are you seeing buyers and sellers deal with that? Is there any kind of fee or reverse break fee that you think becomes applicable, especially in Indian transactions?
Thank you, Nidhi. A very short answer. In Indian M&As, we generally don't see break fee or reverse break fee. While it is very common in the West, not so common in the Indian scenario. It was expected that post-pandemic there will be a lot of emphasis on getting the concepts of reverse fee and finding these concepts being prominent in the Indian M&A scenario, but it has not happened. It is important to understand why it is so. I believe regulatory concerns in relation to payment of break fees is one of the key factors. Say, for instance, any outward remittance of break fee to an offshore acquirer will require approval from RBI. Second one, public companies in India are barred from providing any sort of financial assistance in relation to acquisition of shares, and probably there is an argument that break fees can be considered as part of financial assistance, and therefore gets limited by the Indian Companies Act itself. The last one, I think there is lack of clarity in terms of whether Indian regulators would approve an open offer, or rather offer letter, which is involving payments by the target company in case the closing does not happen. And on account of these, we have generally not seen break fee or reverse break fee being very prominent in Indian M&As. And in my view, Nidhi, unless the regulatory concern surrounding the payment of break fee is resolved, it is unlikely that these concepts will become a norm in the context of Indian M&A.
Yeah, no, I tend to agree with that. And I think another added factor is also that India has a very stringent exchange control regime, right? So, especially when you're dealing with resident and non resident, say, sellers or buyers, the manner in which that payment could potentially be paid out by a resident to a non resident also becomes challenging and could require prior approvals, for example, which may not apply in the context of other jurisdictions where this could be more common in M&A transactions. So, thank you for sharing your experience with us on that, Pashupati. I get the next question is to Rahul, and this is rather interesting. So our audience wants to know if there have been any recent changes to rulings that have been given by courts in India, specifically in the context of financial sponsor sellers, and the kind of tax treatment that they are seeking when they look to sell shares of Indian companies that they have held.
Sure, Nidhi, and that's a very interesting question, and everybody in the fraternity is talking about it. Let me give you a very brief of what is happening, or what has happened rather. Tiger Global and Blackstone both had sold the shares. Tiger Global sold the shares of Flipkart to Walmart and claimed an exemption from India taxes under the India-Mauritius tax treaty. Similarly, Blackstone did a direct transfer of shares in an Indian company, and there was a exemption claimed under the India-Singapore tax treaty. Now, what has happened is the tax authorities disputed it, while the Delhi High Court accepted the position of Tiger Global as well as Blackstone, and the ruling was positive that the capital gains tax exemption is allowed. Now, against that, the department went into an appeal before the Supreme Court, and the Supreme Court has stayed both the orders passed by the Delhi High Court. Now, what does that mean? Does it mean that there is a negative outcome? Not yet. And we'll see how the Supreme Court deals with it. The only change which has happened right now is those positive orders have been kept on hold. But even if you look at without those positive orders as well, if you were to look at the jurisprudence, if you were to look at the circulars issued by the government of India on this very issue, there are ample number of precedents to say that the tax free benefit should be allowed. So, but therefore, what changes in terms of deal dynamics, right? When you're looking at similar situations, similar fact pattern, as a seller, of course, you would want to continue the position. As a buyer, you want to take some additional, checks and balances to be undertaken. You want to look for an insurance, a tax insurance to come in instead of an indemnity, or as an addition to the indemnity to protect yourself. So I would say that in terms of the overall change, while the technical positions are not changing, the commercial
Mm.
positions may need to be more balanced, and you may want to look for additional protections if the situation demands so.
Got it. Thanks for that, Rahul. Interesting, and let's see how that develops. I think that could have a significant impact on how tax indemnities are negotiated, especially for Indian deals. So I'm sure we'll be sure to look out for that one. We have more questions, but like I mentioned at the beginning, we will respond offline if we can't take all of them during the course of this webinar. But I will take the last question, and maybe it would be great, Aishwarya, to have your views on this. The question that we have is, and I think you did mention this during your discussion as well, that oftentimes parties draw a lot of comfort on the indemnity package specifically based on the identity of the parties in question. And so related to that, we see oftentimes that assignment of the rights and obligations under the SSA is typically permitted. And so how do you think that plays in with the discussions we've been having on indemnity? But more specifically, what has been your experience, and what do you think is market for assignment of rights by a purchaser under an SPA post closing?
Yeah, I think Nidhi, as you also said, so much of where we land on the indemnity package is a result of how the purchaser and the seller sort of view each other, right? And aspects like whether the purchaser is known to be particularly aggressive in raising indemnity claims. These are all aspects that a selling shareholder sort of thinks about while offering up indemnities. And obviously, sort of going back to the very first point that I made, it's because for the sellers, indemnities are surviving obligations, right? And therefore, the question on assignability becomes important. Now, I would say that the general starting point in M&A transactions is that neither party can assign their rights or obligations. And it is the purchaser that typically seeks a carve out to this to obviously retain the flexibility to turn over its investment. Now, from a seller's point of view, I would say that they will, we are seeing sellers agree to providing the purchaser some flexibility on assignment, but this is subject to some guardrails. And some of these guardrails, to give you examples, will basically be that the purchaser can assign its rights and obligations only if it's accompanied by a transfer of shares. Second, I would say is that if the seller is transferring its shares in parts or to multiple parties, then the sellers will always try to seek to protect themselves from multiple claims. So they'll say that in instances like this, the purchaser and the assignees should exercise their rights as a block. And I think all of this is also important in sort of in view of the fact that in most SPAs, as Rahul also said, a tax gross up is also agreed, right? So the identity of the purchaser also becomes extremely important. um, so I would say that overall, the starting position in M&A transaction is neither party can assign. There is a carve out available for the purchaser, subject to guardrails. And effectively, in sum, what the seller seeks to protect is that as a result of this assignment, there should be no expansion or adverse impact on the seller's obligations, right? So I think this is where we generally see assignment landing up.
Thanks for that, Aishwarya. It has certainly been a thought-provoking event for me, and I'm especially, happy to be a part of this particular webinar, which is our pilot for the 2025 series, with a topic such as this. Because as a market, we're often tainted with the reputation that, oh, there's no such thing as market in India, and whatever the seller's lawyer or the buyer's lawyer claims to be market lands up being whatever is market on that deal. But I think it's great to see that there are certain principles that can be applied in the context of each of the items that we spoke about today, and to try and establish or decode some kind of where the market is moving towards. And hopefully, the next time we revisit this, maybe in our future webinars, we'll be able to shed some more light on how deals that we've now looked at further since the data that we presented today have either amplified or changed the course of what's happening with Indian M&A deal making. So thank you so much for being with us here today for such an important topic. To me, I think there were I would say the top three key takeaways for me from today's webinar were: one, that indemnity is or continues to be one of those items that buyers and sellers both spend a lot of time on. It is not it's not specific to say that oh, all business warranties will be mapped with a 2 to 4 year indemnification claim process, but it is specific to the facts in question. And as Aishwarya just concluded, that even the identity of the buyer and the seller plays a key role. I think that's extremely important to bear in mind when negotiating some of these indemnification principles, especially in India. The way parties look at tax related claims and non-tax related claims definitely varies. And again, that's a principle that I think one must bear in mind when considering how these are to be negotiated. And I think, like Nayantara mentioned during the webinar as well, we are seeing products becoming more and more viable in the Indian context with respect to, say, products like the rep and warranty insurance, which may come to rescue both in situations of a strategic buyer as well as financial sponsors. We're no longer seeing this be a product that only one particular investor kind or shareholder kind is gearing towards. But always important to keep in mind that the nature of the transaction and the nature of the seller can greatly swing the coverage of the warranties and the indemnification. So this will vary depending on whether it is a 100% sale, whether it is a strategic seller, whether it is a financial sponsor seller, whether it's a minority investment stake, and so on and so forth. So thank you for bringing some of those items to light for our audience today. Before closing, I would like each of our audience members to respond to the poll that's here or should be coming up on your screen. Yes, thank you for that. We take our feedback from each of our sessions very, very seriously as part of our continuous improvement program. So I would request if the audience could kindly provide their feedback on today's session. Thank you to everyone who has participated in the poll. Finally, I would like to thank our speakers for sharing their expertise and experience with us today. You were simply outstanding, if I may say so myself. Thank you so much for being here with us, for spending your time and sharing your experience on all of the items that were discussed today. Also, thanks to you, our audience, for your attention and questions. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, like I mentioned, we will be sure to send you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a slightly detailed or more detailed request for your feedback on this webinar. Please do take the time to send us your feedback. Comments, criticism, and even compliments are very welcome. The form should hopefully take no more than 1 minute of your time to complete, and so we're looking forward to hearing from you. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is right here on the slide. Thank you for your attendance today, and we look forward to being with you again at the M&A Academy.
Thank you, everyone.
Everyone, thank you.
Thank you.
Thank you, everyone.